Okay, today we're going to be talking about chapter 13, which is the chapter on obscenity. I'm going to email you a kind of a chronology of some of the cases, the major cases that we're talking about today. And I want to start with the first case, Roth versus United States, which was passed or decided by the Supreme Court in 1957. And it was the first time that the Supreme Court had ever attempted to define obscenity. And really, it was a long process, and it really continues to a certain extent, where the Supreme Court tries to define what is obscene and what isn't. But in this first definition, I'll just go ahead and read it again. I'll be emailing this to you later. It was defined, just boiling it down to one sentence, whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to prurient interest. Average person, what is an average person? The only thing we know about that is we're talking about adults. Applying contemporary community standards. Contemporary means it's subject to change with time. You may recall that I mentioned Midnight Cowboy, which won the Academy Award in 1969. It was an X-rated movie at that time. Now it's an R-rated movie. The movie hasn't changed, but society has changed. And so usually society becomes more permissive. Now it's, as I said, an R-rated movie. Simply because society has changed. So contemporary means that the definitions could change over time. Community, do they actually mean Cookeville, Tennessee? They could. Roth didn't really say. Now, there could be, as I said, a Cookeville standard, but today it's a statewide standard for obscenity. The dominant theme of the material, this was actually a good thing. It says that you have to look at the entire play, the entire movie, the entire book. And if on balance, it's not obscene, then it's not obscene. You know, you can't pick and choose and say, oh, look here on page 347, here's the F word. So even though that's the only time it appears in the 500-page book, we're going to say that it's obscene. Ross says no, that's not going to be enough. On balance, one mention of the F word in a 500-page book, on balance, that's not obscene. So you look at the entire entity. And then when I first read this definition many years ago of prurient interest, I didn't know what that meant. It means a lewd or lascivious interest in sex, an unnatural interest in sex. So you might say, well, now why are we even studying obscenity? We're not going to be working for some pornographic publication, I assume. Why is it important? Well, as I said, it's the only type of speech that is outside the protection of the First Amendment. So if you're going to say this isn't protected by the First Amendment, then you need to be very careful about getting it right, making it clear what is or isn't obscene. And this is something that the Supreme Court has had trouble doing, as you'll see, during this 16-year process. Because, you know, if something is obscene, not only will you be fined, but you could also be sent to prison. And this is the only area of law that we talk about in this course that isn't just civil law, but a criminal law where you could be put in prison for it for a period of time. To give you an idea of how the Supreme Court itself has struggled with this issue, this is a quote from a Supreme Court justice at the time. His name was John Marshall Harlan, and here's what he said. He says, anyone who undertakes to examine the Supreme Court's decisions since Roth, which have held particular material obscene or not obscene, would find himself in utter bewilderment. So a Supreme Court justice says, I don't really understand what the definition is. And if he doesn't understand it, how can we possibly understand it? Remember, when I was talking about libel law, you have to give fair notice. You know, you have to have the law written down somewhere. And Roth is saying, even though we've written it down, I still don't understand it. One Supreme Court justice said, I know it when I see it. And a lot of people made fun of him for saying that. But I think he had a good point when he said, I know it when I see it, because it's subjective. He knows it. I know it when I see it. You know it when you see it. Some people don't even see it at all. So it's hard to define something that is so indefinable, really, because of its subjectivity. A case that I also will include in the email that I send out to you later on is a case called, in the 1960s, called Jacob Ellis versus Ohio, and it did address the issue of community. It said that we are going to have a nationwide definition of obscenity. We are a national community. But again, that would change too, as you'll see. One of the things I like about studying the law is how lawyers argue certain cases, whether they win or not. I like the fact that they're trying to defend their client as best they can. And this case illustrates this. This is the Edward Mishkin case, Mishkin. And he was I guess we could call him a dirty book peddler who published material that appealed to sadism and masochism. And what his lawyer said was, using the average person concept, our clients' materials do not appeal to the average person. In fact, the average person would be sickened and disgusted by what he is peddling. And so therefore, it doesn't meet the definition of obscenity. Well, William Brennan, who was the person who tried to define obscenity and struggled with this from 57 to 73, he in essence said, nice try. He said, where the material is designed primarily for and primarily disseminated to a clearly defined deviant sexual group rather than the public at large, the prurient appeal requirement of the Roth test is satisfied if the dominant theme of the material, taken as a whole, appeals to the prurient interest of the members of that group. So because the average person in the S&M community would find the prurient appeal, then that's enough. We're going to limit it to that population since it's meant for that population, and that therefore they are the average person in this case. A couple of cases dealing with a man named Ginsburg, one with a Z and one with an S. Now, like in the Press Enterprise case, remember I said that there were two cases and I wouldn't make you distinguish between the two, just know what the two together said. Well, that's going to be the case here with the Ginsburg case. As you know, law is difficult enough without having to say, okay, was that Ginsburg with a Z or Ginsburg with an S? But the Ginsburg with the Z case, the Supreme Court case, dealt with the concept of pandering. And this was where the Supreme Court got off the beaten path, where they stopped just looking at the material itself. They started looking at how the material was marketed, how the material was advertised. The material might not be obscene, but if it's marketed and advertised to customers as if it is obscene, then therefore that's obscene too. Ralph Ginsburg was another dirty book peddler, and he at issue were three publications that he was selling. One was called Eros, which was a hardcover magazine. The other one was Liaison, which was a biweekly newsletter. And the third one was called The Housewife's Handbook on Selective Promiscuity, which was a book. I love that title, Housewife's Handbook on Selective Promiscuity, meaning, I'm going to be promiscuous, but at least I'm going to be selective in my promiscuity. Well, what Ginsburg tried to do is he tried to titillate customers by, as best he could, to say that, this is obscene material here I'm going to send you, so be sure and buy it. And evidence of his pandering, the Supreme Court said, were seen in how he tried to get mailing privileges for Eros magazine. He tried to get the magazine sent from a post office in Intercourse, Pennsylvania. Yes, believe it or not, there is a town in Pennsylvania called Intercourse. And the good people of Intercourse said, no, get your dirty magazine out of Intercourse. We're not going to let you besmirch our good name by sending your dirty magazine through our post office. So sticking with Pennsylvania for some reason, Ralph Ginsburg tried to get mailing privileges at the post office in Blue Ball, Pennsylvania. And Blue Ball, Pennsylvania also said, get out of Pennsylvania. We're not going to let you mail your materials from our post office either. Finally, Ginsburg got mailing privileges for his magazine in Middlesex, New Jersey. But anyway, this was just kind of a silly attempt, I think, to encourage people to buy his maybe obscene publications. Why was the Supreme Court really worried about Blue Ball, Pennsylvania? I mean, what does that really have to do with obscenity? So, as I say, it got even crazier in terms of trying to define it. The other Ginsburg case dealt with a man in New York by the name of Sam Ginsburg with an S. And the thing to remember about this case is that it dealt with the variable obscenity standard. It's essentially said that there are two standards for obscenity in our country. Remember the average person. There is an adult standard and there is a child standard. And the children's standard for obscenity is going to be much more restrictive because children need to be protected from obscene materials. so that was the case there. An example of that would be, say, for example, Playboy magazine. The courts have said that Playboy magazine is not obscene if sold to an adult, but it is obscene if sold to a child. So that would be an example of the variable obscenity standard from Ginsburg in practice. But the big case is the Miller case, 16 years later in 1973, Miller versus California. And I'm going to spend some time on this because it will be on the final. In this case, the Chief Justice, Warren Burger, wrote the majority opinion. And there had been a lot of scientific research about whether obscenity was harmful to society or not. And to what degree was it harmful? Some people thought that it could even be beneficial in some marriages, for instance, the use of obscenity. So what are we going to do with this research saying that it probably could be harmful to society? Well, the Chief Justice said, we're really not going to pay that much attention to the research one way or the other because we're not going to let social scientists define what is legal and what isn't. So reading from his majority decision in Miller, he said, we do not demand of legislatures scientifically certain criteria of legislation, for unprovable assumptions underlie much lawful state regulation of commercial and business affairs. There need not be conclusive proof of a connection between antisocial behavior and obscene material for a state legislature to reasonably conclude that such a connection exists or might exist. A man may be entitled to read an obscene book in his room or expose himself indecently there. We should protect his privacy. But if he demands a right to obtain the books and pictures he wants in the market and to foregather in public places, discreet if you will, but accessible to all, with others who share his taste, then to grant him his right is to affect the world about the rest of us and to impinge on other privacies. Even supposing that each of us can, if he wishes, effectively avert the eye and stop the ear, which in truth we cannot, what is commonly read and seen and heard and done intrudes upon us all, want it or not. Yeah, we're going to be talking about a case in chapter 16, the 7 dirty words. I remember hearing George Carlin talk about that, and he said, well, you can always turn off the radio. Well, what can you do if your young son is in the car with you and you hear that on the radio and then you turn it off? Well, the damage has already been done. I think in that case, the court said it's like running away after the first blow has already been launched. So even though we could shut it out, we really can't. We have to see it first to be offended by it. Brennan, by this time, had decided, oh, I really made a mistake. I opened up a can of worms I shouldn't have. I've been trying 16 years to define what is obscene, and I don't think it can be defined. So he is now in the minority. Other people have taken up his cause, like Berger, but Brennan did write a minority opinion in the Miller case. Here's what he said, in part. I am now inclined to argue that the Constitution protects the right to receive information and ideas, and that this right to receive information and ideas, regardless of their social worth, is fundamental to our free society. It is similarly related to the right of the individual, married or single, to be free from unwanted governmental intrusions into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Now, this was in 1973. So, essentially what Brennan said is that the right to view obscenity is a right of privacy. Now, what other decision, even bigger than this decision, Miller versus California, was decided by the Supreme Court in 1973? Anyone? Anyone? Okay, it was the case of Roe versus Wade. And Roe versus Wade dealt with the same privacy issue, that a woman is entitled to get an abortion, and it is her right based on her decision in consultation with her doctor. It's a right of privacy as well. So Brennan saw obscenity in the same way as he viewed the right to get an abortion, so that it was a right of privacy under the Constitution. Okay, another case dealing with obscenity actually happened before the Miller case. It was a case in 1969 called Stanley versus Georgia, And it too really was tied to a right of privacy. And the majority opinion in this case was written this time by Justice Thurgood Marshall. And he said, if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch. So the Supreme Court says, what we're really interested in is the distribution of pornography. We want to stop the distribution of pornography. If it's already in your home, we're not going to go in your home and take it, but we're going to try our best to keep it out of your home if it is indeed obscene. So this leads us to our next case, a case called New York versus Ferber, and it dealt with child pornography. And in this particular case, the Supreme Court said that it is not legal to possess child pornography, even if you didn't make it. If you purchased it or downloaded it on your computer, for instance, that's illegal. And there were people who said, well, now, wait a minute, that's contrary to what Stanley versus Georgia said. Stanley versus Georgia said if it's in your home, then it's protected under privacy. But the Supreme Court said no. Child pornography is not a First Amendment issue. It is an issue of child abuse. And if we can drive up the market for child pornography by making it illegal merely to possess it, then so much the better. We're not keeping people from expressing their First Amendment views, because after all, obscenity is outside the protection of the First Amendment. But child pornography is so insidious that we're not even going to let you possess it in the privacy of your home because you're contributing to a crime, the exploitation of children. Okay, another topic that's talked about in this chapter 13 is, and it's also a term that harkens back to libel law, is the term center knowledge or guilty knowledge. In that case, in libel and also in obscenity, the courts have said you have to have knowledge of what your books contain, or you can be absolved from it if it's causing the dissemination of information of otherwise protected speech, if it's causing it to be not to be disseminated. And this was a case coming out of California in 1959 called Smith versus California, dealing with, okay, what if somebody is selling material that may or may not be obscene? You know, what will happen, and it happens with libel law too, is really kind of censoring yourself, saying, well, you know, I do sell materials that are of a sexual nature, so I just won't do that anymore. Well, you know, just because it's of a sexual nature doesn't mean that it's obscene. And it's a problem because you're not even allowing it to go to court. You're saying, I might win, I might lose, but I don't want to have to pay all this money to go to court to distribute this material, so I just won't distribute it at all, even though it may not be obscene. Brennan said in this case in 1959, he said, if the bookseller is criminally liable without knowledge of the contents, he will tend to restrict the books he sells to those he has inspected, and thus the state will have imposed a restriction upon the distribution of constitutionally protected as well as obscene literature. You know, you say you have a bookstore, and there's a book there that you sell, among many books, that is of a sexual nature. Well, you know, if you are legally responsible for the content of all the books you'll sell, you'll only be selling books that you've read, right? And you should be able to read books that the bookseller hasn't read. You know, just because he hasn't read it shouldn't be a reason that you can't read it. So in many instances, the bookseller is not going to have guilty knowledge. They're not going to have center knowledge, and they're not responsible for reading all of the inventory that they sell. Going back to Miller versus California, a couple of things that the Miller versus California case did in overturning Roth. One was that it said that it's just silly to have one national definition of obscenity, that we're just too diverse of a country to do that. Berger wrote, our nation is simply too big and diverse for this court to reasonably expect that such standards could be articulated for all 50 states in a single formulation. You know, Let liberal Nevada be liberal. Let conservative Tennessee be conservative. If they want to get it down to the community level, they can. Tennessee, I think, wisely said, no, we're just going to have one statewide standard for all our communities. But we're going to let the states come up with their own definition of obscenity, provided that they follow our parameters here in Miller versus California. There's a three-part test in Miller versus California. I think it's on page 489. And the community standard is the first of those three standards. Another standard that's mentioned in Miller versus California is the standard of a material is obscene if it lacks serious literary, artistic, political, or scientific value. So in that case, that's actually kind of a liberal definition. It's saying, okay, you can argue before a court that your material does have some good value to society and it not be declared obscene. You know, just because it's a dirty book doesn't necessarily mean that it has no value at all. So you can concede that perhaps it doesn't have a lot of value, but some people might find this article or this magazine helpful or beneficial. And so therefore we argue that it is protected by the First Amendment because it does have some value. It's not totally worthless, in other words. Let's see, what else? Yeah, Brennan, I talked about Brennan deciding that he could not define obscenity and therefore they should stop. In this Miller decision, he talked about a chilling effect. And this is something, again, from libel law, where people don't have fair notice. You know, ignorance of the law is no excuse, but the law still needs to be written down. And Brennan feared that even though they have been writing it down for 16 years, it's really not clear, even 16 years later, whether it is obscene or not. He wrote in his Miller dissent, I am convinced that the approach initiated 15 years ago in Roth versus United States, culminating in the court's decision today, cannot bring stability to this area of the law without jeopardizing First Amendment values. And I have concluded that the time has come to make a significant departure from that approach. But as I said, others had taken up his cause, and he went from the majority to the minority because he changed his mind about obscenity. There are a couple other cases since Miller versus California. Miller versus California is still the law of the land, but as you know by now, the Supreme Court is still going to revisit issues because lower courts need further help from the high court as to what the definition really means. So the very next year in Hamling versus United States, 1974, the Supreme Court said this. This court has emphasized on more than one occasion that a principal concern in requiring that a judgment be made on the basis of contemporary community standards is to assure that the material is judged neither on the basis of each juror's personal opinion, nor by its effect on a particular sensitive or insensitive person or group. So what Hamling is saying is that what you are to do is you are to look at the entire community and let that decision guide you as a juror. We'll use Tennessee as an example. Say you're on the jury of a obscenity trial case and you say, well, you know, I'm kind of a liberal guy, and so, you know, my definition is probably more permissive than the average person in Tennessee. But what Hamling says is you're not supposed to do that as a juror. You're supposed to say, okay, even though I'm kind of a liberal guy, I know that I live in a conservative state, and so I'm going to follow this more conservative definition of obscenity than my own. Hamling says don't do that. But just because the law says something, I'm not convinced that that's what happens. I don't think people do that. I think people probably say, if they're a juror, they're going to say, well, I think I'm an average person. I think that my view is typical, and so I'm just going to go with what I think, even though what you think may be contrary to what the majority of your fellow Tennesseans think. So it may be well-intended, but I'm not sure how practical that Hamling decision is. I'll give you an example of the effects of Hamling. One of the things that Hamling says is that, say there's a dirty book peddler in New York State, and you read about this material and you want it, and you live in Nebraska. And you say, okay, I would like to order this material, and it is trucked from New York to Nebraska. If you are a prosecuting attorney and you want to get a conviction of this dirty book peddler, Do you bring a prosecution in New York or do you bring it in Nebraska? I would say you've got a better chance of winning a conviction in Nebraska because Nebraska is a more conservative state. In fact, what it's called shopping for venue, and it's actually legal. If the material was trucked, as I said, over land rather than flown in an airplane, you have the right to bring a case in any state in which those trucks rolled, any state between New York and Nebraska. Nebraska would probably serve the purpose, though, because I'd say Nebraska is one of the more conservative states in our country. But that's what shopping for venue is. So again, Hamling may have been intended to clarify Miller versus California, but I don't know that it actually did. So the confusion really continues. The last case I wanted to talk about today comes from Georgia as well. It's also in 1974, and it was a movie called Carnal Knowledge, starring Anne Margaret and Jack Nicholson, and believe it or not, Art Garfunkel was in it. He actually did a pretty good job of acting. And the people of Georgia back in the 1970s said, we feel like that carnal knowledge is obscene. And the Supreme Court has said that as a state, we can decide whether it's obscene or not. And we say that it is. Well, the Supreme Court said, no, you misunderstood Miller. Yes, you do have the right to determine as a state what is obscene, but you have to follow our parameters. And one of our parameters, I think it's the second of the three-part Miller test on page 489, says that the material must be patently offensive. And even though this movie is somewhat risque, it is not a porno flick. In fact, it was nominated for an Academy Award as well. It was just a movie that dealt with the topic of sex. So even in the conservative state of Georgia, it's not obscene under our standards. What patently offensive means, without getting too explicit, although I think Chapter 13 does get explicit if you actually want to read the definition, but really, patently offensive means hardcore. There's hardcore pornography, which is really obscenity, and then there's pornography. Obscenity and pornography are not interchangeable. Pornography would be softcore. Pornography is protected by the First Amendment. Obscenity is not. I guess what I would say about the distinction between the two is that hardcore pornography leaves nothing to the imagination, whereas softcore pornography, which is protected by the First Amendment, is more suggestive. It does leave things to the imagination, thankfully. Okay, that's it for now. I will be seeing you later on. Have a good day.